I'm not.
I'll tell you when you're used 10 minutes.
That's fine. Judge, I just want to make a few points here.
Okay, go ahead.
Good morning, ladies and gentlemen of the jury. Listen, I was thinking this morning about what I would say to you, and I'm going to start out because I knew this was coming. 42 years, 43, I've been doing this. These are seasoned prosecutors, okay? Make no mistake about it. And I was anticipating their theatrics. And believe me, there's going to be more to come. Raising your voice, pacing, ranting, raging. That's not evidence in the case. So I'm going to talk to you, something I typically don't do. I'm actually going to keep my voice down and kind of walk through a couple things I just want to encourage you to talk about when you're there, because Mr. Maroon, you know, he talks about what he thinks the evidence is and how our client didn't do this and he didn't do that. So let me start out with, I want to turn on and talk to you about a couple things. Remember when Rossi was on the stand and I walked up with the code and I asked her to review what a prosecutor's duty is? Remember when she agreed with me that the prosecutor's primary duty is not to seek a conviction? Okay, that's not the primary duty. It's to see that justice is served. And make no bones about it, Arlene deserves justice. Okay, she does. Thankfully, we know from the evidence in this trial that if and when they ever prosecute the suspect who started this whole series of events in motion, they have video of him. You saw him robbing Tony and his wife. You saw him running. You saw him jumping over a fence. At the very end, they put that up. Clearly, after all of this had occurred, you see this guy climbing over the fence, and they have a pretty good shot of him. I can't tell you how they'll prosecute that person and what arguments they'll make to his jury, but I can talk to you about the evidence in this case. And here's the thing. We talked about how you don't secret evidence. Okay, you put it all out there. You let the juries decide. And here's what I hope some of you want to get the discussion going on in deliberations, is that we spent hours and hours and hours of listening to them talk about the what. Well, we all knew the what. We told you the what up front. Tony shot into the truck. Okay. But we had to listen to angles. We had to listen to all the scientific evidence. But if you notice, what they brought you was people who either work for their office, okay, or someone who works for the Montgomery County's District Attorney's Office, okay? But we didn't hear from some critical people. And let's talk about that. I want to put the overhead up. Well, the first thing I want to talk to you about is, well, it was here, but it's that little USB that has State's Exhibit number 108 in it. Now, no, it's obvious through this trial that this is the techie. This man and Zach Caldwell, they are the techies. I don't profess to be a techie. I can't make digital exhibits. I'm the guy, probably the only person here who's still writing on a yellow legal pad. Okay? But if you recall, okay, Zachary Caldwell gets on the stand and they're going to play, I'm sure we're going to see it. It might be part of the theatrics. Put it in slow motion and show the call-outs, the call-outs, the call-outs. Boom, boom. It didn't happen. It happened real fast. Now, I don't know if it's deliberate. Maybe it's an oversight. I don't know. Okay, I can't tell you which one because I'm not in their heads. And maybe they can just say Zachary Caldwell decided to leave out the 5 shots. And let's talk about that because Andrew was pretty straight up. Okay, for 35 years on the police force, he's heard gunshots. Okay, so he said, he kept asking him, are they gunshots? And he goes, well, in my opinion, I believe they were gunshots. Okay, and so as I walked back, I even pointed out that Rossi, their expert, the woman is an expert in almost everything, but she was still in the courtroom hearing that. And I said, basically asked them, get him repeat it because they would have the ability to rebut with her. They could put her back on the stand. Here's what they didn't do though, okay? They whoever did it, whether Caldwell or whoever instructed, whenever they talked about, they intentionally left it off the call outs. And I'm calling them out on it because we showed you A, B, C, and D, if I can publish this, shows that the call outs would have registered. And if you wanted to do an accurate compilation, then A, B, C, and D would have been on it, okay? Now, if you notice, we closed. They didn't call Rossi back. They didn't address the call outs that they eliminated from that States 108 exhibit. They could have called her back and she could have said, in all my years and all my experience and all my education, I think we heard about everything she did since kindergarten. But we stipulated she's an expert, and she didn't dispute the fact that those were gunshots. They didn't address it straight up, okay? Nor did they address it after the fact, okay? And so that is, it's kind of a misleading exhibit, okay? I'm gonna use that word. It misleads the jury. You know, you get to consider, and we've said it all along, you got to consider the why, okay? The why. And he made reference to, we don't need to bring a detective here. Well, let me show you a couple of things too. And I think you should talk about, and hopefully someone will bring it up. And listen, a lot of the theatrics and a lot of the walking around and the yelling and moving up close to the jury, you know, everybody here, they're good lawyers. I like to think I'm a good lawyer, okay? I'm going to try to keep my voice down. But, you know, they make emotional arguments to incite emotion. And if you get back there and you keep talking about the emotion, look, it's a tragedy, man. I can't even comprehend what it must be like for the family, all right? The foreman, whoever you are or she is, whoever becomes the foreman, it's going to be your job to say, look, we can't use prejudice or bias or emotion. Let's look at the facts, and let's look at all the facts, the totality of circumstances, okay, when we're deciding. So quickly, because I don't want to use all of the time, but State's Exhibit number 23. Look, I think they even agree it was the worst, one of the worst investigations you'll ever see as far as collecting the evidence. I mean, he couldn't even identify these two guys in the suits that are talking there. We know from the facts in this case that the one guy on the left, if you can compare, look at his head, we know that he's the same person who interviewed Tony Earls, okay, in this exhibit right here. Here's Tony being spoken to by the detective. And Andrew said, 35 years I've been doing this, and it's not routinely we call a detective. So there's two things that they kept from you. They kept from you the detective's opinions, of whatever they may have been from the case, about what he felt, the guy who was out there that night, okay? And they're going to tell you, oh, they could have called him. Well, we don't have the burden of proof. They do. So look at it, look at the fact and consider the fact that that's, you know, something they kept from you, okay? And then the fact that our client gave a statement. He's interviewed shortly following this event. And here's what this shows you. I mean, you can basically see his demeanor when he's speaking to the detectives, okay? Now, you know, I think even Andrew or Rossi had said, we can't introduce our client's statement. Okay, we're not allowed. They can, they have it, okay? And what it tells you that it's what he's thinking, because they're obviously talking about it. So here's what they kept from you, okay? And let me say this, you got instructions. The fact that they can't call him to the stand, and I can tell him whether or not to take the stand. I'm just going to tell you that, like the judge told you in the very beginning of the trial, there's all kinds of reasons. Packed courtroom, skilled, very skilled prosecutors. You could take all kinds of things into consideration.
Just to give you a,
I'm sorry, I have a few left.
for 10 minutes. You can take as much time as you want.
Okay.
I'm saying you asked for 10 minutes.
I'll need just a couple more. So I think it's important to recognize that that you shouldn't just consider the what, you got to consider the why, okay? And part of the why is what he's obviously talking to the detective about. And so I hope that at least some of you are offended or moved by the fact that they kept this information from you. And you, I would encourage you, because he brought it up, use your common sense. If the detective had a favorable opinion to their case,
Objection, improper argument outside the record, and false.
Don't be sustained.
okay, well, Judge, I don't know what his opinion is. I'm just saying,
Because it's outside the record, he's not allowed to argue.
It's sustained. Please move forward,
okay,
sir.
all right. So you don't know what his opinion was because they didn't bring it to you. You don't know what Tony Earls told them or spoke about with the detective because they kept it from you. Okay? They neatly went out at most a month or two before this trial, okay? And they put together this group of prosecuting employees and had them develop with, let's see, they needed months and, a drone. They needed lasers. They needed, I don't know, I think there was some tripods and meters and everything, but they can't tell you about the speed of the vehicle. Look, I'm gonna let Ed talk to you about the charge, okay? And Anna's gonna talk to you about a few things, but I do want to go to page 7 since Maroon made an issue of it. And the language says you have to consider while making no effort to determine the identity of the occupants of the motor vehicle. While making no effort to determine the occupants, okay, of the vehicle. Well, so here's what you do. Rather than just using their graphics during closing, a boom, 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 and the stills that they did with Rossi, all I ask is you do this. Talk about the speed of the vehicles, and the videos have it for real. The sound out there, including what he tried to refer to, I think, as somebody packing their cigarettes. It's probably a statement he'd like to pull back on. The sound, the sight line, and the split-second timing and the limited lighting, okay? So when you talk about how you might have reacted or someone might have reacted, just look at all the facts, okay? As far as what he saw, we know he intersected the truck, okay? And his determination was started with being robbed, followed by the robber running in the exact direction of the truck, that going right up to the truck and the truck emerging, okay? So he had facts to make a determination, but he had to make he made a split-second decision. So I think that he's right about one thing. You probably don't get too far into this charge because of that issue if you consider all of the facts. And I can say it for Ed, I can say it for Anna. Actually, I want to say it for Mr. Earls, that I think if you consider everything, then in that instance, not just the watt and just the video, the stills of him shooting into the truck, that you should render a verdict of not guilty. Thanks, guys.
Mr. McLeese, as soon as you have 31 minutes and 25 seconds.
Thank you, Judge. I will not be taking all of that.
And what kind of reminder do you want?
10 minutes, Judge. Just give me 1 moment if you don't mind for this thing to get caught up. It takes a minute.
I pause your time.
Good morning. I'd like to start off by saying something that is obvious but needs to be said. And that is what happened to Arlene is horrible. It's tragic. It's every parent's worst nightmare. I don't wish that upon anybody. The Alvarez family did not deserve that. They do not deserve the pain that they're going through. Okay. We are not here to suggest otherwise. We never have been. I don't think you think we are, but that needs to be said. And you're about to be given a superhuman, Herculean task that's very hard to do. And that is to separate this tragedy from your duties as jurors under the law. Okay. You've got to put aside the heartstrings that they're about to get up and pull on heavily. All right. They're very good at it. They're going to get up and pull on that heavily. But I do think that when you look at the instructions that are given to you by this judge, okay, these instructions called a jury charge, 20 plus pages of instructions, your guidebook, okay, it's going to take you to the right result here, the just result. In this case, okay, let's talk about what you're here to decide, what you're here not to decide. You're not here to put a stamp of approval upon anything that happened. That's not it. You're solely here to decide whether or not the state proved beyond all reasonable doubt whether Tony was reckless that night from his standpoint. Okay, when we say reckless, we're also, and I'm going to go over this in more detail in a minute. We're not saying the word reckless like we might say if we're having a cup of coffee. Okay, it's a very specific legal definition that you're going to need to apply. Now, I've got a couple of things up here that we first visited about in jury selection. Remember, this is the presumption of innocence, all right? Maroon, Mr. Catani like to talk about order of things in the jury charge. This is the first one, presumption of innocence. Your default setting is not guilty. And to get beyond that, they've got to prove everything to you beyond a reasonable doubt. Now, along with what Mr. also said, they spent a whole lot of time over a week dissecting, to use Mr. Jordan's words, frame by frame by frame of something that we've never really contested, and that is that the gunshot came from Tony Earls. Okay, I wish it didn't, but it did. That's the situation that we're in. But what you need to look at, you need to guard against legal sleight of hands that are being done. Okay, and it is not insignificant the decisions that are made by prosecutors who are this experienced to not include any investigators, any detectives. There were multiple ones out there. We heard about that. None of them came to you. Okay, they brought one first responding police officer to you. They brought a couple of the crime scene people to you. But think about what they did not bring. All right. That didn't make you wonder why. That's not by accident. Okay, we introduced the crime scene video. They didn't. Why? Not by accident. There's a lot that they're wanting to take, to use the analogy Mr. also made earlier. They're in the replay booth trying to circle, receiver that may have been open and not considering it from Tony's standpoint with everything that he had going on. So let's look at the specific allegations. All right. And this is good. I took some bullet points here, but this is what it is. He's accused of recklessly causing the death of Arlene Alvarez by discharging a firearm in the direction of a motor vehicle. And then this is the weird one, while making no effort to determine the identity of the occupants of the motor vehicle. It's up to you to determine whether that constitutes recklessness. Okay. We are here to say that under these circumstances, it does not. We are not saying there's open season on shooting cars. All right. That's not our point. This is a very, very, very unique set of circumstances. So manslaughter is our charge, recklessly causing the death of an individual. This is where I think they failed. All right. This is where they failed. They have to prove beyond all reasonable doubt that Tony was aware of, but consciously disregarded these risks. And I'm here to tell you, it's not just the risks of a firearm, okay? It's this specific set of circumstances, okay? How could Tony have known that given everything that went on here? This is a tragedy. It's a tragedy. But him being involved in this tragedy does not make him a criminal. This is where we start off, okay? They never showed you this picture. We had to bring it to you. Why? Because they don't like it. Because it humanizes Tony. He's just trying to make a deposit so he can go to dinner. That's all they're trying to do. And a gun gets put in their face. That's an experience I hope no one else in here has to go through. I can't imagine the horror. It's nighttime, and you're seeing your entire life pass before your eyes, and then it triggers. We heard Dr. Lambert talk about this. It starts to trigger chemical reactions in our body. All right. And it gives us, Mr. Jordan, very skillful cross-examiner, was trying to make it sound like you're either in fight mode or you're in flight mode or you're in fear. I'm here to tell you, as the doctor did, these all converge. Okay. These all converge. This is a chaotic, terror-filled situation. All of these emotions, all of these things are converging, and Tony is reacting. He's reacting. He's not even, we heard about that, the whole frontal lobe starts to shut down. He is reacting to the situation. So we have at the very beginning, and I'm going to tell you, this is a fluid situation at the very beginning, and they concede this, okay? When he's shooting under Texas law, he is allowed to shoot at this guy, okay? He's allowed to. There's not any dispute on that any more than there's any dispute that Tony's the one that shot at the car, okay? These are things that are not in dispute. At that point, okay, they think that as we get to the vehicle, that Tony should have made an effort to determine the identity of the occupants of the vehicle, and that it was not reasonable for him to not do so. But what I'll suggest to you is when we look at the evidence, and look, y'all can get all of it. Look at it as much as you want. Okay, go through it. But you need to go through it. The law is instructing you, you do this from the actor's standpoint, from Tony's standpoint, all right? That chase sign, yellow circle, right? And this is what I was talking about. And this horrible constellation of events. You've got right as the robber is running, all right? He goes behind that sign, and it happened to be right when the truck is slowing down. It's not Armando's fault he was slowing the truck down. He's dealing with the same stuff everyone else is in this situation, trying to figure out what to do. We're not blaming him. But right as the truck slows down, that is the exact time that the runner's there. It's right behind that chase sign. It was, I am going to tell you, a reasonable thought for Tony to believe that that truck that was slowing down, you see the brake lights on right there, okay, that it was picking up the robber. And at that point, it became a threat where he is allowed to defend himself. Okay, because you can watch the video, watch the way the truck's maneuvering. Tony doesn't know what's going on. He is firing as rapidly as he can because he is in fight or flight mode. All right. His self-defense is presumed reasonable. This is on page 9 of your jury charge. Okay, if he knew that the person against whom force was used, okay, and he believes he's using it against the robber, and I believe, and I'm submitting to you, that's a reasonable belief based on this evidence. He did not provoke the deadly force of the robber. No one's suggesting he did that. He was not otherwise engaged in criminal activity. Okay. With that, there's a presumption there on self-defense. And I'm going to get to what Mr. Catani was talking about, the innocent third person here in a minute, but I'm going to preview here for you. Okay. All of this, everything we're talking about concerns recklessness. If the first definition you need to look at when you get back there is recklessness. Was he aware? Was he actually aware? There's a separate charge for when you ought to be aware. Okay, there's a separate charge. That's not what they brought here. They brought is aware. Okay, and once the self-defense issue is raised, and you'll read it here, this isn't me, this is instructions coming from the court. Once self-defense is raised, they have to prove beyond all reasonable doubt that he did not act in self-defense. Okay, that's and it's been raised. So that is also on their burden. Not only do they have to prove that he acted recklessly, they have to prove that he did not act in self-defense. All right. So to prevail, they essentially have to say that Tony did not believe his conduct was immediately necessary to protect himself or against the robber, and that his belief was not reasonable. All right, so this is something that they've done a lot of work, the prosecutors have, to try to minimize this. Okay, and one of their witnesses was even saying, well, I don't know if that's a gun. What do we do? Again, like I question with the witness, he ain't waving goodbye to Tony over there. Now, On this one, this particular shot, is Tony's view blocked? Perhaps, okay? But there's 2 times where we see him, where we see the robber with his hand back like that, all right? Once before that truck, once after the truck. And I'll submit to you that if he did it before the truck, he did it after the truck, he very well may have done it here when we're not able to see him, all right? I've never heard of the state giving so much benefit to an aggravated robber as they have in this case. And the reason that they're doing that is because we know good and well the robber should be in this chair. He's the most responsible. But they got to have someone that they can get a scalp from to give you. Reckless injury to a third person. Again, don't be distracted by this, okay? This is all if you do not believe that Tony was reckless, and we're telling you he was not, then this is irrelevant, all right? So for you to believe that he was reckless, you have to believe that he knew. He understood that after the stress of this event, when he's having a gun pointed at him, and he doesn't know what's going on, okay? And by the way, let me also say this. There's a lot of confusion as to whether or not he's being fired upon. All right. Armando was confused by that. Tony was confused by that. And I'll tell you, in a situation like that, I'm not blaming anybody except the robber. It is natural to be confused when your head is being flooded with such conflicting information. Okay. Again, from his standpoint, what he saw looked like the robber was getting in there. We know that the robber was at the very least pointing guns in a direction. All right. So with all this, we look at this with what we call the totality of the circumstance. And I'll tell you, they did not meet the burden of proof here. They did not prove to you beyond all reasonable doubt that Tony that Tony knew that this was going to be the result. No one thinks, and I don't think they're even going to say that Tony woke up that morning wanting to hurt anybody. We all know that. We're here because of horrible circumstances. A lot of people in the wrong place at the wrong time, and a robber who's not here. I'm going to turn over the floor to Ms. Funes.
You have 17 minutes and 40 seconds. 17:36.
This case starts with heartbreak. We've all acknowledged that. No one here thinks that what happened that day is not a tragedy. Tony doesn't think that that's not a tragedy. You have to separate emotion from this case. When you get back there, you have to separate emotion. You have to follow the law. Every time that you feel like emotion is taking over, because it's normal, it's natural. There's a dead 9-year-old. We all acknowledge that. We know that. We've acknowledged that every step of the way. Every time you feel that emotion taken over, we ask that you step back and you follow the law. We ask that you remember the facts of this case. All the people that they've brought to you, I believe it was Mr. Caldwell. He said, I think the jury would benefit from pausing and slowing it down in order to better understand it. Well, guess who didn't get to pause and slow down? Tony. Tony didn't get to slow down and pause what was happening. He had seconds to make a life or death decision. Mr. Alvarez twice under oath, said they were shooting at each other. He believed they were shooting at each other. That is what he saw. And Dr. Lambert said that is normal. His reaction is just as normal as Tony's reaction. It all happened so fast. Does that mean Mr. Alvarez was lying? No. What he believes he saw may have been accurate. It all happened so fast. It was traumatic for everybody involved. There was a gun pointed at Tony and his wife. They want you to forget about that. They don't want you to think about that because the robber's not here, because nobody has found the robber. Because the person who should be sitting right there is the robber. They reminded you over and over that you're citizens of Harris County. As citizens of Harris County, you should be demanding that the robber be sitting there. Believe it was CSU told you, well, no, we didn't swab anything. The swabs are too expensive. So you have a robber who pointed a gun at a family, who caused all of this, a dead 9-year-old, and CSU comes in and tells you, well, no, we didn't swab. Swabs are too expensive. We heard that there was a Detective Farrell. Where is he? Why didn't they bring him in? The undisputed facts. They brought you people, like Mr. also said, who only got involved in this case a couple of months ago. This case has been going on for 3.5 years. They brought you people that would show you things slow down from their perspective, not from Tony's perspective, not people who were involved in the investigation. And Mr. Catania was very adamant about that last shot. When Tony gets out of the car and he says, well, he made that last shot as he's pulling out of the car, out of the driveway. Well, did he forget that he also showed us that video where the Alvarez family and Mr. Alvarez testified he's waiting at the street, down the street for Tony. You see his brake lights in the reflection. He waits 17 seconds. He's waiting down the street. And as Tony's wife is pulling out, they realize they're waiting on them. He then reverses.
Outside the record.
The jury heard
That's what the
evidence in
video
this case.
shows.
Same in Marshall, like, when, you know, evidence comes from the stand, you guys get to believe who you want to believe. I mean, you may continue.
He reverses by his own testimony. He says he reversed. He then makes a U-turn and decides he's going to chase Tony. How is Tony not supposed to think that the truck is involved in the robbery? He thinks the robber's coming back for me. That's what that last shot is. The robber's coming back for me. I am in fear for my life. It's not this, I'm just going to shoot down the street. The robber's down the street waiting on me. That's what Tony believed. He said, I waited, I reversed, I made a U-turn and started chasing him. Call it whatever you want. he tried to say, no, I wasn't going to chase him. It wasn't a chase. It wasn't a chase. He chased him, and you see it in the video. Now, they each may have been erroneous in what they believed, but Tony thought the truck was involved in the robbery. How was he not supposed to think that the truck is involved when he gets out and sees him waiting on him? What else is he supposed to believe? Now, these 5 shots that Mr. Catani says, it's just somebody packing cigarettes. Packing cigarettes. Well, you know who could have told us whether it was packing cigarettes or 5 shots? The detective. Why didn't they bring him? He would have answered that question. So yeah, we're left to speculate whether it was shots or not. In his opening, Mr. Jordan said, Tony had a right to shoot the robber. He told you that. We don't change the evidence to fit the theory of the case. The evidence is what the evidence is. Twice, Mr. Alvarez said they were shooting at each other. Like Mr. also said, things that they didn't bring you. The detective, the CSU video that we had to introduce, and what Tony told them. When you get back there, you can ask for a readback of what Mr. Alvarez said from the stand. Now we watch the body camera. As soon as the police arrive on the scene, Mr. Alvarez says he thought we were involved with the robber. That's why Tony shoots. He's not just out there shooting at random vehicles. He's not this angry person that Mr. Jordan would like him to be. He thought we were involved with the robber. See the brake lights. You see them waiting. Why didn't they bring you the camera from the front of the building that would have shown Mr. Alvarez's truck? All we have is a reflection. All the things they didn't bring you. But they want to make up for it with emotion. Yes, there's a dead 9-year-old. We know that. But you still have to bring the evidence. You still have to prove your case. You don't get to make up for it with emotion. We don't convict people based on emotion. One of you during jury selection said that's why he was here, because he believed in the justice system. We don't convict people based on emotion. We convict on the law. We follow the law. Based on the law, you must find Tony Earls, not guilty.
$26 minutes and 25 seconds.
I'm gonna set it up first. You stop my time first.
Never started.